Welcome to iEnhance Student. iEnhance Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us Khushal Pandya. He is going to deliver a lecture on Public Interest Litigation. He is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Khushal to commence with his lecture. Thank you.
Good morning everyone. Today I am excited to dwell into a topic that lies at the heart of social justice and legal reform. It is the topic that everyone should know about it. It's the P.I.L, Public Interest Litigation. To start considering this powerful thought given by none other than our father of the nation, Mahatma Gandhi. The best way to find yourself is to lose yourself in service of others. Before starting or dwelling into the topic of P.I.L, I would ask you everyone that what is right? Rights. Rights are divided into two parts. One, the individual rights, and the second, the community rights. The individual rights are also known as natural rights or human rights. Human rights such as right to life, right to liberty, right to freedom of speech and expression, right to education, right to environment, and right from slavery. Without everyone is entitled to rights. If an individual right has been harmed or infringed, it is the state are responsible for protecting the civil, education, economical, social and cultural rights of the people. Here comes the second right. If we talk about the community rights, those rights are protecting the rights of community. The group that have historically faced discrimination over the period of years. If any community rights has been harmed, then the judicial intervention take place on a larger scale. A right that citizen is not aware of, it's the P.I.L, the Public Interest Litigation. When the interest of community is harmed, P.I.L comes into the picture. P.I.L in India refers to a larger maxim where a public spirit citizen or a group of individual or a group of a public welfare whose voice is silent, who cannot approach to the court, who may not have a reason or a power to go to the court to fight for their rights, P.I.L is a key instrument for them to go and raise their voice. This gives courts the ability to get involved for the issue related to public health, human rights, the environmental problem and social concern. You will be shocked to know that the P.I.L was not mentioned in any article, any act, any statute. There were no specific sections defined for the P.I.L. So the question arises, how the P.I.L came into the picture? The P.I.L was originated from US Constitution in 1960. But the point raised here is, how P.I.L came to India? Public interest litigation first came to India in early 1980s. The emerge of P.I.L in India mainly attributed to the judicial activism of Supreme Court. Justice P.N. Bhagwati and Justice V.R. Krishnaiyer were main pioneers of P.I.L. They were the one who introduced public interest litigation in India for the first time. They were the one who facilitated by the relaxation of rule, traditional rule, locus standi. The rule, the locus standi says that only that person whose right has been infringed can move to the court for their remedies. The rule of P.I.L gives some of the exception to the traditional rule of locus standi. All Indian citizen or a group of organization or a public welfare can go to two courts. First, the Supreme Court under Article 32 of the Indian Constitution, and second, to the High Court under Article 226 of the Indian Constitution. But, however, the person or an organization filing a P.I.L, the petition must prove to the court that the P.I.L is being filed not for the personal interest or a personal motive. There should be an interest and a benefit to a larger public. You will shocked to know that the first P.I.L, means the public interest litigation, was filed in the year 1979 with a landmark case named Kushanarayan Court versus State of Bihar. This P.I.L was filed by none other than the lady lawyer Pushpa Kapila Hingorani. lawyer Pushpa Kapila Hingorani filed the first public interest litigation in the Supreme Court of India. The case mainly focuses on the inhuman condition in Bihar jail, inmates and under trial prisoners. The petition was filed by the under trial prisoners as well as Hingorani ji argued before the bench led by none other than Justice P.N. Bhagwati. The court ruled that the prisoners have the fundamental rights under Article 21 of our Indian Constitution for speedy trial. Because of this, efforts of Justice Hingorani, efforts led to release almost 40,000 of under trial prisoners. And this considers as a landmark case in the history of public interest litigation in India. Due to this success of Pushpa Kapila Hingorani ji, Hingorani sometimes called as the mother of public interest litigation in India. Now, we everyone know that in school or institution there are some guidelines that we need to follow as a students, as a professor. Same year, Supreme Court has given us the guidelines for admitting the P.I.L. No petition involving personal interest or personal matter entertaining as a P.I.L. The court should promote genuine and legitimate P.I.L. The High Court should establish competitive P.I.L. that encourage genuine and discourage those who are benefited for personal interest. The court should verify that the quality and the experience of the petitioner should be great, as well as the accuracy, the validity of the content of the petition before admitting a P.I.L. Every court has a P.I.L. committee or a P.I.L. cell. The work of the P.I.L. committee or the P.I.L. cell is a registrar is allotted. Their job is to scrutinize the P.I.L. and to check whether the P.I.L. is for the public benefit or for the public welfare or for the personal motive. P.I.L. committee or a P.I.L. cell is like a water filter. How the water from filter gets pure and drop into the pot. Same way, P.I.L. cell checks every inch detail, checks whether the P.I.L. which is formed by the petitioner is getting into the legal system or not. If no, then the P.I.L. is disowned. It won't be transferred to the court further. If yes, it is genuine and legitimate, then P.I.L. will go to the court. And it is the court that ensures that the petitioner that involve larger public interest, gravity and urgency will give more priority. P.I.L. such as bonded laborers, negligent children, non-payment of minimum wages, petition from jail complaining for harassment, petition against police for refusing registering of FIRs, harassment by police and death in the police custody are main prioritized by the court. Here comes another case law on the Banda Mukti Morcha versus Union of India, year 1984, the Supreme Court case in India. This case talk about the assistance of bonded laborers in the country of India. The Banda Mukti Morcha filed the case to the Supreme Court, an NGO that established in 1981 to fight against the bonded laborers. The BMM, the Banda Mukti Morcha, asked Supreme Court to investigate the inhuman condition that the bonded laborers faced while working underground in mine coal, living without property, water, food and shelter. The BMM attaches the thumb impression of bonded laborers to letter send it to the Supreme Court. Note, you can also write a letter to the Chief Justice of India that can also be treated as a P.I.L. Let us understand the simple and the basic procedure of filing a public interest litigation, my friend. Identify the issue. The person filing the P.I.L. must undertake the issue concerning at a larger scale. He must be researched all the thing that the P.I.L. need. The petition must collect all the necessary information that the P.I.L. need. Second, draft the petition containing the issue, name of the court, name and address of the petitioner and the opposition, the respondent, including the relevant facts, figures and the evidence. Third, submit the petition to the court or to the appropriate court. In many jurisdictions, P.I.L. are filed in High Court, such as High Court or Supreme Court. Pay are required. There is 50 rupees per P.I.L. file and other charges that will be included by the advocate or by the lawyers. If the petition filing the P.I.L. to the High Court, then he or she must submit at least 2 copies of the petition to the court. In case of Supreme Court, at least 5 copies of petition to be submitted to the court. Here comes the 4th process. The court will review the petition that has been filed by the public individual or by the public committee. 5th, hearing will be take place. The court may schedule hearing to protect and to assume the P.I.L. 5th and 6th and the last is the judgment day. The court will deliver the judgment based on the argument and the evidence form. Now, there are always a unique point which has been raised in P.I.L. is that these unique points are unaware by the people. The points are specialized team. The court sometimes set up a specialized team to handle issues of P.I.L. like environmental pollution team to protect our environment. There are court assistants. Judge often appoint expert called as query, named as friend of a court. Legal expert or lawyer appointed by the court are appointed them to solve the problem of P.I.L. Last, public input. In some time, P.I.L. case cause the public comes into the picture for the whole of hearing, get more information because of any discussion. Court may issue public notice in newspapers or outlets to get public input for the P.I.L. P.I.L. can be led new news or changes in new laws. The court find that current law are inadequate. The quid emphasize the spirit of P.I.L., which is fundamentally talking about serving of the people. Now, there are always advantage and disadvantage. Every coin has at least 2 sides. So, the public should be aware that the P.I.L. are fined in a noble cause and not for the personal benefit. Sometimes, general public misuse. Over the period of years, the P.I.L. has been used in India or by organization for filing it favorable for political interference or for troubling the opposition or for harassment or for the personal benefit. This led to rise in burden of judiciary. The introduction of P.I.L. in India has led a significant rise in Indian court to case pending before the overburdened cases. But, as I said, every coin has 2 sides. So, the primary objective behind filing a P.I.L. is to provide justice to all and to promote the welfare of the people. I advise 3 things. First, stay informed and aware. Second, use P.I.L. responsibly. Third, support NGO activities. Here, I conclude myself by saying that the P.I.L. in India has emerged as a powerful instrument or a weapon for promoting social justice. So, not everyone is aware about the P.I.L. However, it is used efficiently by NGOs, by lawyers or by activists. So, I give you a short advice is that use P.I.L. for the personal welfare, for the public welfare and not for the personal use. Thank you.
Khushal, thank you very much. It was nice hearing the entire concept of P.I.L. and as rightly advised by you, I think everybody should be cautious that it has to be used only and only for the public cause and not to achieve your own scores and not to achieve your own targets. Thank you very much. This is a small token from us.